Hello. We at Winchester Law thank you for visiting our website. As you may have seen either on this blog or on TV, we recently put out a commercial involving a young child chastising his parents on their lack of estate planning. Because we feel these issues are important ones that every parent should know about, we thought it would be helpful to post a short video explaining the issues discussed in the commercial in more detail, as it relates to estate planning and their kids. The first is who will take care of the children should one or both spouses die, and the second being how any property they leave to their minor children will be managed. Turning to the first of those two questions, one of the biggest worries most parents have is what will happen to their children if they die. Who will take care of them? Answering this question requires an understanding of how the process of guardianship works. Guardianship is a court-supervised process whereby a non-parent is appointed as a child's caretaker. While not the same as adoption, the guardian will act as a child's parent in many respects. For example, a guardian will house the child, decide where they go to school, and pay for support costs like food, school supplies, and medical care. The appointment of a guardian is subject to a finding by a court that the appointment is in the best interests of the child. This is called the best interests test, and if a court determines that a particular individual's appointment as guardian is not in the best interests of the child, that person will not be confirmed as guardian, even if that person was specifically nominated by the child's parents. So how does guardianship work in practice? Well, looking at the chart on this slide, we can see that there are really two possible paths. In the first path, only one parent has died, while the other survives. In this instance, the answer of who takes care of the children is intuitively obvious. The surviving parent will take care of the children, and there is generally no need for a guardianship hearing. The second path on the chart, involving a situation where both parents have died while their children are still minors, is where a guardianship proceeding will be necessary. This path branches off into two further possibilities: situations where there is no will, or where there is a will, but that will does not nominate a guardian, and situations where the parents have nominated a guardian in their wills. The first situation is the one discussed in the commercial. The young boy, who we will call Kyle, is worried that his parents have not done any planning and that he will therefore become either a ward of the state or be raised by crazy Aunt Belinda. Kyle's fears about being a ward of the state may be mostly unfounded. Since there is clearly surviving family, at least in the form of Aunt Belinda, it is unlikely that Kyle would be subject to state care for any great length of time. However, without a more specific nomination by his parents in a will, there is a distinct possibility that Aunt Belinda could be named as guardian, even if she is not someone Kyle or his parents would have preferred. Although the commercial is lacking in details about what makes Aunt Belinda crazy, keep in mind that mere oddness or eccentricity is likely not going to prevent a court from naming Aunt Belinda as guardian, particularly if no one else has come forward for the role. Other risks of not nominating a guardian include increasing the length of the guardianship proceedings, which may delay or hinder a child receiving necessary services or support, and conflicts between surviving family members who may all want to be guardians, particularly if different branches of the family have different opinions about how to raise a child. For these reasons, it is always good planning for parents of minor children to nominate a guardian for their children in their wills. For one, it allows the parent some degree of control over the process. If they have a particular opinion about how they want their child raised, they can nominate someone whose views coincide with their own. While nominating a guardian in a will does not eliminate the need for a guardianship proceeding, it does greatly simplify the process. The court does not need to go looking for a guardian because the parents have already nominated someone who is presumably willing and able to accept the responsibility. And although any person nominated as guardian in a will is still going to be subject to the best interests test, a court will generally not attempt to second-guess a parent's choice of guardian, and the suitability of a nominated individual may be subject to less scrutiny than if no guardian had been nominated. Let's turn now to the second major question many parents have regarding their children, namely, how does their property pass to their kids? Like guardianships, there are two main possibilities as to how minor children might receive property after the death of both parents. The first is via a custodial account established under the Uniform Transfers to Minors Act. This will occur when both parents of a minor child die either without a will or with a will that includes no specific trust provisions. Under a UTMA custodial account, property that would otherwise pass to a minor child is instead held by a custodian, appointed by the estate's personal representative. The custodian holds and manages the property on behalf of a minor child until that child turns 21, at which point the custodial account terminates and the property is distributed to the child. A UTMA custodial account can be thought of as the default, as it would be the option used unless specific action is taken by the parents to avoid it. For example, a child subject to a custodial account gains an absolute right to any property in the account when they turn 21, and some parents may feel that 21 is too young an age for a child to receive a potentially large amount of property. Additionally, parents may want the property held or used for specific purposes. Although the property in a custodial account is generally used for a child's health, education, maintenance, and support, parents may have more specific uses for the funds in mind. For these reasons, parents with minor children may wish to establish a testamentary trust. A testamentary trust is a trust created through language in a will. Like a UTMA custodial account, a testamentary trust would take effect only if both parents died while their children were below a certain age. However, a testamentary trust allows the parents a greater degree of control over the property as well as the standards of distribution. For example, the parents may place language in the trust stating that their children receive the trust property only when the youngest of them reaches a certain age, say 30, or when specific conditions have been met, such as a child graduating from college. Making the choice between a trust and a UTMA custodial account is one that will be different for every individual. Talking with an attorney can help parents decide which choice is best for their situation and, if a trust is chosen, help make decisions about how to structure that trust.